Hey everybody, in today's video, I'm going to talk about the differences between a Chapter 7 bankruptcy and a Chapter 13 bankruptcy. My name is John Skiba, and I'm a bankruptcy attorney in the state of Arizona. And one of the questions I get asked quite frequently is, really, what are my options between Chapter 7 and 13? What are the main differences? And why would one person choose one chapter over the other?
Consumer warrior is on your side. The consumer warrior.
Today on this video, I'm going to give you 4 differences between a Chapter 7 bankruptcy and a Chapter 13 bankruptcy. And then if you hang around to the end, I'm going to share with you how you can decide which chapter is best for you. Let's talk about, first of all, there's Chapter 7, which is what overwhelmingly most cases are filed under. And then there's Chapter 13, which these are the 2 main consumer types of bankruptcies, meaning these are the types of bankruptcies that individuals and families or couples file when they're going through the bankruptcy process. So the first difference between a Chapter 7 and a Chapter 13 is the amount of time that you're going to be in the bankruptcy case. Now, Chapter 7s are relatively straightforward. A typical Chapter 7 bankruptcy takes about 4 to 5 months from the time it's filed with the court until you receive your discharge order from your judge that says all of those debts are eliminated. Now, in contrast, a Chapter 13 is much longer. It is a 3 to 5 year process. Most Chapter 13 bankruptcies are 5 years, a full 60 months, but in certain circumstances, they can be as low as 36 months. But they cannot be less than 3 years, and they cannot be more than 5 years. So if you're looking between Chapter 7 and Chapter 13, one of the big advantages for most people is that Chapter 7 is relatively quick. For a federal proceeding, it's relatively quick. Chapter 13, much longer. You're going to be in there for several years before you're going to get that final discharge order that says the balance of your debts are eliminated. Now, the second big difference between a Chapter 7 and a Chapter 13 is how your assets are treated in the bankruptcy. Now, the big picture idea of a Chapter 7 bankruptcy is they're going to eliminate all of your debts, all of your unsecured debts for the most part are going to go away completely. They're going to be discharged. You're not going to have to make any payments on them. They're just going to go away in that relatively short period of time. However, the trade-off in a Chapter 7 is if you have non-exempt assets, the bankruptcy court, and more specifically the bankruptcy trustee, can seize those assets, sell them, and make a distribution to your creditors. Now, it's important to know that most assets are exempt. Each state has different exemption laws, and there are federal exemptions as well that protect certain property. For example, most people have heard of the homestead exemption before that protects equity in your home. In most states, like Arizona, where I practice, like your vehicle is exempt, money, a certain amount of money in a bank account, household goods, retirement accounts. Most things are exempt and protected, and thus in a Chapter 7, most people don't lose much of anything, if anything at all. I would say about 95% of people do not lose anything that go through the Chapter 7 bankruptcy process. Now, Chapter 13 is different because you will not lose any assets, whether they are exempt or not exempt. They're not going to be taken from you. The reason being is that you are going to be making a payment to your creditors over that 3 to 5 year window. So if you have assets that are not exempt in a Chapter 7, like let's say you had like a boat that was paid for, in most jurisdictions, that's not going to be exempt. Where in a Chapter 13, you're not going to lose that, whereas in a Chapter 7, you may. So if you have assets that you're worried about losing that are not exempt, they're not protected by one of the exemptions, Chapter 13 is often a better option. Now, third thing, which I alluded to there, the big difference is payment to creditors. In most Chapter 7 bankruptcies, there is no payment made to your unsecured creditors. Now, it's important to know if in Chapter 7, if you have a mortgage and you want to keep your house, you need to continue to make the monthly payments on it. If you have a car loan that you want to keep the car, you're going to need to continue to make those payments. But credit cards, medical debts, those types of things, those you do not need to continue to make payments because they are going to be eliminated completely. And the court's not going to require you to make any payments on those during the Chapter 7 process. Now, Chapter 13 is completely different. In a Chapter 13, you and your bankruptcy attorney will prepare a plan. It's called the Chapter 13 plan that's proposed to the court and to your creditors, where you will pay back a certain portion of the amounts that are owed to the unsecured creditors specifically. Now, the question I get all the time is, okay, great, how much? How much am I going to have to pay? It is very fact specific to your situation. So it is a very difficult question to answer without knowing all the details of your situation. I can tell you this. Here are the factors, though, that we look at in determining how much is going to be paid to those unsecured creditors. First, we look at your income. Second, we look at your monthly expenses. And then we look to see, is there any disposable income? After you pay the basic living expenses, is there any money left over that could go to your creditors? Now, that is a good indicator of approximately how much you're actually going to have to pay. So, for example, if you were to file a Chapter 13 bankruptcy, we take your income minus your expenses, and there's $500 left over that could go to your unsecured creditors, then that would likely be the amount that would go to your creditors. However, there is one other factor that we look at, and that is if you have non-exempt assets. Essentially, in the Chapter 13, the court says, look,
your unsecured creditors cannot be treated differently just because you filed a Chapter 13
over a Chapter 7. And so we look to see, is there any non-exempt assets in a Chapter 7 that would have been sold and money distributed to your creditors? If there is, then that amount would have to be paid to your creditors in a Chapter 13, which is kind of confusing. But let me use a real-world example. So let's say you live in a state where boats are not exempt. They're not protected. If you were to file a Chapter 7 bankruptcy, that boat could then be sold and then the money distributed to your creditors. So let's say you had a boat, let's say it was worth $5,000. In a Chapter 7, it gets sold and they distribute $5,000 to your creditors. In a Chapter 13, then, your creditors, your unsecured creditors like credit cards, personal loans, medical bills, they must get at least the same amount that you gave your creditors in a Chapter 7. Well, in a Chapter 7, when we sold the boat, it was $5,000. So in the Chapter 13, they're going to have to get at least $5,000. Now, it's important to note that we're also, again, going to look at income and monthly expenses, and we're going to mesh those two together to get a planned payment that meets all the requirements of the bankruptcy code, provides some payment to your unsecured creditors, but also at the end of that 5-year period of that Chapter 13, it will eliminate any remaining balance on the credit cards, personal loans, medical bills. It's also important to know in most jurisdictions, like in Arizona where I practice, they actually require you to pay your car payment through the monthly plan as well. So the way that creditors are dealt with, assets, payments, in a Chapter 13, you're going to pay back more of your debt, whereas in a Chapter 7, you're not going to pay back any of the amounts due on those credit cards or medical bills, those types of things. Let's talk about the fourth thing, and that's one that's near and dear to my heart. That's attorney's fees. Attorney's fees are dealt differently in a Chapter 7 as compared to a 13. Now, one thing you might guess, typically in a Chapter 13, the fees are higher. And that is because if you're in a Chapter 13 bankruptcy and you hire me to be your attorney, we're likely going to be friends for 5 years as you go through this process. There's much more work involved as it's a much longer process. However, it's typically done on flat fees, at least in most jurisdictions, it's done on flat fees as well. And often the bankruptcy court will set the flat fee in a Chapter 13. So attorneys will generally charge roughly the same amount. Now, a Chapter 7, the amount of time and the amount of work is typically less. And so it's often something where you're not paying out as much in attorney's fees. And in a Chapter 7, some states require the fees to be paid in full upfront. Other jurisdictions like Arizona, they do allow you to make payments over time. In a Chapter 13, usually a portion of the fee is due up front, and then the balance is paid out through the life of your case. Logistically, how a Chapter 13 works is you're actually making a monthly payment to the bankruptcy trustee, who then distributes that money out to your creditors. If you have attorney's fees that have been rolled into your Chapter 13 plan, a portion of that would be paid like to my office over the balance of your case. So attorney's fees is another area where we look to see the differences between Chapter 7 and Chapter 13. Now, those are the four main differences. Let's talk about why you would choose a Chapter 7 or a Chapter 13 over the other. Now, many people initially say Chapter 13, that doesn't sound very fun. We're do this for 5 years compared to 4 or 5 months in a Chapter 7. The number one reason people file a Chapter 7 over a Chapter 13 is that they do qualify for a Chapter 7. Chapter 7, you do have to qualify for something called the means test. The means test is they're going to look at your income, your household size, and they're going to determine if you make at or below the standard income in your particular state. If you make more than the average household of your size in your state, you will likely have to file a Chapter 13 bankruptcy. Now, those numbers change all of the time. That's something you can look at the United States Trustees website, or you can contact a bankruptcy attorney in your state, because the income levels vary depending on the number of people in your household, depending on the year, and depending on the state. So it does vary quite a bit. And so you need to get up-to-date information to determine if you do qualify for a Chapter 7. But even if you qualify for a Chapter 7, there may be a reason to do a Chapter 13 bankruptcy. And that reason is that you have assets that you're worried about losing. Like we talked about in a Chapter 7, your assets can be sold and then money distributed to your creditors. Well, if you have an asset you do not want to lose, but you still need bankruptcy relief, you can keep the asset, file a Chapter 13, and just pay out money to your creditors based upon that Chapter 13 plan. Still eliminate most of the debt that you're dealing with, but at the same time, be able to keep your asset. A third reason is if you're behind on secured debt payments, Chapter 13 is going to be of a big benefit to you. So in a Chapter 13 case, if you're behind on your mortgage or if you're behind on your car loans, you can file the Chapter 13 bankruptcy. It immediately stops any collections against you. They can't garnish you, foreclose on homes. They can't sue you. And so often when people come to me and they say, John, I'm 4 months behind on my mortgage, they're threatening to foreclose, we could file a Chapter 13 bankruptcy, stop the foreclosure process, stop even the collection process, and then propose a plan where you pay back those missed payments over a 5-year window. The same can be done with vehicles. So it makes it much easier to get current on things like house payments and allow you to get current on it and avoid a foreclosure altogether. So I hope that helps you if you're trying to decide between Chapter 7 and 13, or if you've talked to an attorney and you're not quite sure as far as which way to go with it. Those are the main reasons and the main differences you're going to see in the bankruptcy process for consumers, whether it's a Chapter 7, which is short and sweet, gets rid of a lot of debt, but carries some risk of being able to lose assets, and you have to qualify for it. Whereas a Chapter 13 is usually preferable if you don't qualify for a 7, or if you have assets that you're worried about losing. So hopefully that's helped. If you are in the state of Arizona and you need a bankruptcy attorney to help you, I can help you. Contact information is below. Reach out, set up an appointment. I'll be happy to see which chapter is best for you and how you can get that debt in the rearview mirror once and for all.
Consumer warrior.